Excellencies, distinguished guests, colleagues, and members of civil society, I'm honored to join you today and to address you in my capacity as UN Special Rapporteur on the independence of judges and lawyers. My mandate is firmly rooted in the principle that the rule of law and the fair administration of justice are essential to the protection of all human rights. At the very heart of these norms lies the fundamental human right to a public trial. This right is not merely a procedural formality, it is a vital guarantee that ensures transparency, fosters accountability, and reinforces the independence and the impartiality of the judiciary. It protects both the individual and the public interest in the fair administration of justice. Today, I focus on a case that gravely illustrates the challenges to judicial independence and the right to a public trial. The case of Mr. Arnon Nampa, a prominent human rights lawyer. Mr. Nampa is a founding member of Thai Lawyers for Human Rights, which provides free legal assistance, particularly to individuals in vulnerable situations. Mr. Nampa has fairly undertaken highly sensitive cases, including representing civilians before military courts, defending individuals charged under Article 112 or the Lèse Majesté statute, and handling cases related to constitutional amendments, monarchy reforms, and environmental activism. Indeed, he has represented some 50 human rights defenders, pro-democracy activists, and political dissidents in criminal cases since late 2020. As with too many human rights lawyers globally, Arnon Nampa has himself become the target of criminalization. On June 25, 2025, Mr. Nampa faced his ninth Lèse Majesté conviction. This conviction stemmed from a speech he delivered in December 2020, where he highlighted critical issues facing the Thai legal system and society. The criminal court in this instance found him guilty under Section 112 for the crime of Lèse Majesté for alleging that the monarchy had appropriated public assets for personal use, ruling that even if such a transfer occurred, he had no right to make defamatory statements. He was sentenced in this case to 4 years in prison under Lèse Majesté, which was reduced to 2 years and 8 months due to his valuable testimony. This brings his total sentence to 26 years, 9 months, and 20 days, with Lèse Majesté accounting for more than 25 years of that total. He has been detained since September 26, 2023, and still faces 5 additional Lèse Majesté cases. He is appealing all his convictions. It is concerning that on the day of his verdict, June 25, 2025, there was a clear attempt by the criminal court to hold a secret verdict hearing. Mr. Nampa was transferred from Bangkok Remand Prison not to the scheduled courtroom, but to an arraignment room on the first floor. Despite the courtroom being attended by his family, members of the public, civil society organizations, and embassy representatives, the judge ordered the verdict to be delivered in secret in the arraignment room, permitting only Mr. Nampa's family and lawyers to be present. The court cited security concerns related to a small protest. However, the defense insisted on a public hearing, leading to a prolonged debate. Eventually, the court relented, allowing the verdict to be delivered in the courtroom, but only with a handful of close relatives and legal representatives. Many attendees were forced to leave, while some insisted on their right to witness a public trial. The verdict was finally read almost an hour and a half after the scheduled time. This incident marks the second documented instance where the court has tried to hold a secret verdict hearing for Mr. Nampa, the first being his contempt of court case in March 2025, where the verdict was read in an arraignment room without public or family presence. This practice directly contravenes the Thai Criminal Procedure Code, which explicitly requires judgments to be read in an open court. This erosion of transparency is deeply troubling. The principle of public trials is firmly embedded in international human rights law. Article 10 of the Universal Declaration of Human Rights affirms that everyone is entitled to, in full equality, to a fair and public hearing by an independent and impartial tribunal. This foundational right is echoed in Article 14 of the International Covenant on Civil and Political Rights, which guarantees all persons the right to a fair and public hearing by a competent, independent, and impartial tribunal established by law. From the perspective of my mandate, the public character of judicial proceedings serves as a critical safeguard for judicial independence. It permits oversight of judicial conduct, deters misconduct or abuse, and reassures the public that justice is not only done, but is seen to be done. A public trial also serves to protect the rights of those accused of crimes, ensuring that legal proceedings adhere to the highest standards of fairness, due process, and equality before the law. Without such openness, there's a heightened risk of secret trials, arbitrary detention, and denial of access to justice, practices that have no place in a society governed by the rule of law. Furthermore, public trials cultivate trust that the judiciary is impartial, and trust that justice will be delivered without fear or favor. While international law does permit narrowly defined exceptions, for example, to protect the interest of minors, victims of sexual violence, or national security, such limitations must be exceptional, justified by law, and subject to strict scrutiny. The presumption must always be in favor of openness. Beyond the direct issue of public trials, I'd like to share my serious concerns regarding ongoing disbarment proceedings against Mr. Nampa before the Lawyers' Council of Thailand, which appear to be a reprisal for his legitimate exercise of human rights and professional duties. Concerns about the impartiality of these proceedings include the appointment of an investigative committee chairperson with alleged close links to the military government, which Mr. Nampa has publicly criticized. Mr. Nampa's case highlights the imperative to uphold several fundamental human rights protections of special concern for my mandate, including the independence of the legal profession, freedom of expression of lawyers, the right to a fair trial, and of course, the right to a public trial. My colleagues and I have urged Thailand to provide detailed information on the allegations concerning due process violations in this case, and to explain how the disbarment proceedings and the restrictions on judicial transparency are compatible with the government's obligations under the International Covenant on Civil and Political Rights. We will continue to monitor this situation closely, and we urge that all necessary interim measures be taken to halt the alleged violations against Mr. Nampa. I'd also like to recommend that steps be immediately taken to ensure public trial is guaranteed. Justice thrives in the open. Let us ensure it remains there. Thank you very much.